Before we go into the general discussion period, let me make 2 quick points. Number 1, I want to thank the members of the audience for being here and for participating. And number 2, on your behalf, and as a representative of the Department of Linguistics, also of the College of Humanities and the University of Utah, I want to say what an enormous privilege it has been to have such a great assemblage of the top forensic linguists in the country come here and instruct us on these really important matters and make valuable contributions, not just to our academic understanding, but also to the way we interact and connect with legal professionals, law enforcement, and other people. And it was a great privilege to see so many very important people here this morning who represent those areas of domains of life that are so important to all of us in our society. So if you'll join me in thanking our speakers once more. So as I mentioned before, we do have some time for a general discussion. We have an hour allotted to that. If it doesn't take that long, then that's fine, no problem. We will end early. Just a couple of things. So we are live streaming this, and the video from this forum will later be made available for playback, video playback. We have 2 microphones here. One is for this auditorium. The other one right here is going into the camera itself for live playback. If you have any comments, I invite you to come up here to the podium and make those comments directly into the microphone. And if you have any questions, you can either come up here and make those into the microphone, or you can also ask your questions from there, and then whoever answers those questions will come up here and repeat those questions.
About the live streaming, will this be available later?
It will be, yes.
Can you give us information on how to access that?
Yes, I'll send that to you a little bit later, but for those of you who are in the audience, the link to the playback will be available on the forum website on the main page.
And we'll then send it to forensic linguistics.
Oh yeah, thank you.
Can I make a comment?
Yes, please do.
Thank you. I'd just like to say, and I know we all think this, for what a fabulous job you and Annette and your staff has done, and we just applaud you for putting this together. Thank you very, very much.
Good, thank you. So I'll repeat the question, and then perhaps one of you would like to come up and answer it. The question is that given how non-native speakers of English often run into problems with their Miranda rights, if they know how to invoke their right to an attorney and have that attorney come and help them out, will that solve the problem? Did I get the question correct? Yes. Would any of you like to come and answer that question? Yes, Mark.
I think I'm just going to answer one piece of it, and I'm sure others will have other comments on it, but sometimes attorneys don't realize the limitations of their own defendants' English proficiency, and they will assume that if they can talk one-on-one in an interview, that there is no need to go out and search for an interpreter and to set one up for trial. And I was on an appeal case in which the attorney had not done that. And and they also will I think sometimes they just don't realize the limitations, and they think that one-on-one communication will negotiate things, and it won't be the same thing as what happens in a trial. And then in this particular case, I think the judge decided that, in fact, an interpreter was needed, and there had been fault found against the attorney for negligence. I may not have all the legal angles on this correctly stated, but maybe others have other comments on that.
Just follow up on what Margaret said, and it is true that attorneys sometimes don't understand the need for an interpreter, and it's not that simple as an all or none thing. In cases I advised on, sometimes this defendant did not need the interpreter to talk, but he needed the interpreting to understand. And that is a very common thing. So he had a Russian English interpreter who would interpret everything that's going on, but then he himself could answer the questions in his own simple English. And I must say that it did not necessarily make a good impression on the judge, because the judge suspected that they were faking, well, they can talk, why do they need an interpreter? But this is where we come in to educate the general public that it's not that simple. I don't know if that answers your question, whether lawyers are always advocates. My own answer is that they themselves do not always understand all the intricacies of working with interpreters and what needs and can be done.
On the cases that I've done, there seems to be a pattern, not all the time, but there is a pattern where a defendant gets arrested, and as you saw this morning, there's an interrogation, etc. And then they are either given a lawyer or they go to a lawyer, and a huge number of cases in the United States are plea bargained, right? And so their first contact lawyer just says, okay, take the plea, and works on a plea. And then in that one case I showed this morning where there was the coercive interrogation, one member of that young man's extended family said no, and she convinced the family to go off and get a much better lawyer, a much more expensive lawyer, and so forth, but it was worth it. And so I think it depends, I don't know whether it's a good thing or not, but it depends upon the quality of the lawyer and the willingness of the defendant to basically fight.
What happened finally in that case?
There was a hung jury, and then they retried, and then I was getting ready to fly down there and do it all, and then the prosecution basically organised a much lower charge that was really felony, just to save face. On another case, a public defender, one public defender, and this is I really have a lot of admiration for the people that do public defending, but one public defender, just without even actually talking to the client, sort of organised a plea, and once again a member of his family stepped in and said, no, we're going to fight this, and in that case they walked away free without anything. So I think there's a quality of lawyer and the family's willingness to fight that steps in there.
And it goes through all layers of interactions with the jurisprudence system. I just worked on a case in Washington State, I think, where a man had been convicted, and the lawyers were seeing whether they could get a habeas on ineffective assistance of counsel because he spoke Urdu and he could speak English, supposedly. But it was very clear when we examined the transcript that he at many times had no idea what was going on, and he did The district attorney mocked him because she says, he said he didn't even know what an erection was. So you can imagine what kind of case it was, and she's using the fact that this guy stumbled because he had no idea what was going on at that junction in time. Did you ever get an erection? He said, no. Oh, well then how do you have all these children? So she was playing with him, you see, and really preying on his non-native ability. And his attorney didn't know how to fight back, and he did not have an interpreter. And everything that everybody has said is 100% true. You give a very, very bad indication if you look like you're just, I remember Khrushchev, an old premier of Russia, always used an interpreter, and it was the predominant opinion in the United States that Khrushchev spoke very, very good English. He was just using this to get another 20 minutes of planning what he was going to say, you see, and just putting everybody through their paces. But the other side of the coin is that, especially us Americans, we want stuff to be done now. We don't have any time. We need instant, let's get going with this. Well, let's not wait for an interpreter from some language that I've never heard of before because this guy speaks English. He speaks English? I speak English, you speak English? And then they go on. But your point is a very, very good one because you have identified the most critical juncture. It is when the person doesn't have an attorney, ineffectively even knows what an attorney is, and if they get an attorney, they're going to be a lot better off, and odds are the attorney, of course, is going to say, don't say anything, which, if I were a police officer, I probably wouldn't think was the best outcome, right? So that's another problem.
I have been looking at transcripts of capital cases for about 25 years, and I've also done training for defense counsel dealing with interpreters. And what I've seen is that people have various mythology about interpreters, and as you say, one of the problems is the defense attorney's calculus about what their witness, whether it's the defendant or other witnesses, how they will be perceived by the judge and jury if they do or do not use an interpreter. And I think that there is a bunch of mythology that is not always accurate about that. I've heard attorneys who had no competence in the language to which they would have needed an interpreter, was Amharic, I believe, say that the reason they did not want to present their client via an interpreter, even though his English was nowhere near perfect, was because they were worried about discrepancies between his testimony and the first statement that he made, which might be introduced by interpretation. So that's one attitude. I think another huge problem is that when you have interpreter problems in the transcript, unless the attorney stands up, jumps up and down, and objects vociferously, the interpreter issues are waved aside on appeal. They get no traction. And just as attorneys since Padilla versus Kentucky are learning more about how bad it is to have what the attorney might consider a good outcome in terms of plea bargain on the criminal case, which renders your client instantly deportable, just as attorneys are learning more about their immigrant or minority clients in that context, I think they're being forced also to learn more about non-native speakers, and that's helpful. So just an aside.
Two quick comments. One is following up on what was just said. As I said, I'm married to an attorney. He happens to be an immigration attorney. And one thing he repeatedly encounters is clients who have plea bargained and their criminal attorney worked out a plea bargain, and the attorney and the judge said to them, and when you've done whatever we've told you to do, for example, community service or whatever, you never have to tell anyone this has happened. And then the client is in is somewhere in the immigration proceedings and has to go for hearings or whatever. The court system may forget. The Immigration and Customs Enforcement does not forget. And so even though people have been told by judges, okay, you don't ever have to tell anyone this, it's going to show up on the ICE records. So this gets back to this question of when is an attorney actually going to be able to be a good advocate? Because if the attorney doesn't understand certain things about immigration law, they're not going to be able to be the criminal attorney is not going to be a good advocate for someone who may also have immigration issues. I think the other situation that you're going to encounter is a slightly different one where someone is Mirandized and then they get themselves an attorney. And I assume several of us have dealt with those cases, and there, what the attorney is likely to try to do is want the expert to come in and make the claim that this person couldn't possibly have understood their Miranda rights when they were given to them. In some cases, there will be recordings. That's great if you've got that evidence. In many cases, there won't. Well, immediately, for those, if you've got any language teaching experience, you appreciate, you're trying to assess now what somebody's ability was a year and a half ago before they spent a year incarcerated in an environment where English is the dominant language. And so how are you going to even think about those kinds of things? And it's not to say that, you do the best you can if you are indeed offering the assessment, but even that also presents a different set, but a great set of challenges. So certainly, you want legal representation. On the other hand, you've also got to be very careful about the legal representation that you end up with if you have any choice in the matter.
Thank you. Mariana, did you have a question?
You touched on it. I'll just stand up here so I don't have to
Okay.
walk over everything. One of the things that worried me about this question was that partly what you touched on, by the time. Okay.
Yeah, thank you.
The concern would be that by the time you get an attorney, it would be too late. You've already gotten into the legal system because you probably have already waived your Miranda rights, right? You've been Mirandized, you don't understand anything, and then all of a sudden, all of this bad stuff that has happened to you because you didn't understand will be hard to undo. So really, we have to stop. The intervention has to come before that. Right, and I think that's what most of you have made pretty clear, that the intervention has to come before that, so the assessment has to come before that, and who's ready and able in our current legal system to do that? Who's ready and able to pull that trigger, or who will be willing to pull that trigger? And unless all of that is front-ended, we have a serious human rights issue. And so it's some concern.
So there are two things that we can take away from all this that most of us are very familiar with. One is that things should always be recorded, and at the very, very least sound recorded. And the other is that interpretation of some form or another should be readily and easily available for the poor, hardworking cops who have, as big a caseload as the public defenders do. And there is such a thing as I forget what it's called exactly, but one of my students is in it as a Russian and English interpreter, where you call up the bank and you get the person on duty. And if you're lucky, it's actually some dialect that somebody might understand. But I was involved when I was the New Jersey interpreter for the New Jersey court system for Swahili. It took them around 8 months to find me. As you can imagine, you can't just look it up in the phone book. And the problem of dialect was very, very severe, because I would a couple of times be asked to interpret, and it turned out that They were Congolese, and this was Katanga Swahili, which maybe if we tried hard, I would understand better than the judge, but it wasn't ideal. So this one case that I was involved with, a man was accused of some sexual misconduct, and the detectives produced an extensive confession, and it was transcribed by a secretary who had worked with this detective group for 20 years. And there was audiovisual equipment in the room, there was sound recording in the room, and the defense attorney said, was any of this used? No. Why not? It didn't occur to us. So the man this guy was also from the Congo, he said that he didn't speak English. So how the hell could he have written that confession? And matter of fact, he barely knew what was going on. So the hearing that I was involved with, which must have cost the great state of New Jersey, I don't know, $100,000 at least, was to establish whether he spoke English or not. And all they would have had to do was turn that thing on. And there was a very poignant cross-cultural issue. He said that the detectives brought him upstairs and they started banging him around, just slapping him around and knocking him into a wall and things, which didn't bother him at all. He was from a place where there was very brutal gendarmerie. And then they told him to sit down in that chair. And the chair had an electrical cord on it, just haphazardly. I don't think these New Jersey detectives were going to attach electrodes to him, but in Congo, that was where he was from, it was a very common thing. And he was relating this on the stand, and he started crying uncontrollably. And of course, nobody in the courtroom but me understood what was going on, and as we know, as an interpreter, you're not allowed to step out of it and say, can I explain what's going on? And that had so much verisimilitude that I believed him. And of course, I didn't know if he spoke English or not. I just knew that, and all right, one last little anecdote in that of what else can go wrong. He was actually a Lingala speaker and not a native Swahili speaker, but he had lived in Nairobi briefly, so he spoke a post-Pidgin Swahili that is current in Nairobi, and I know pretty well. So he was tracing his comings and goings, and in Nairobi Swahili, we use English all the time. So we might say, halafu nilikwenda University of Nairobi, halafu nikaenda Pwani. You know, I went to Nairobi, and then I went to the University of Nairobi, and then I went to the coast. So upon uttering the words University of Nairobi, the prosecutor jumped up and said, see, he speaks English. And, as we know, the official language of the U.S. courts is English. So there was no recording being made of anything but the English. When I interpreted, that's what was written down. And I said, no, that's what, shush, you can't say it. And there's no recording. And it also pushes one into the unenviable position of being an advocate. I'm not supposed to be an advocate, I'm supposed to be the interpreter. In the immortal words of the non-linguist lawyer that I once, one more anecdote. So 2 Zanzibari people were in an accident on Long Island. And it was amusing, too, because I was looking for them and they were looking for me, the interpreter, and they expected me to be an African. I expected them to be Africans, but there were Zanzibari Indians, Kati and Gujarati speakers, but Swahili was their first language. So this was a car accident. There were 5 different lawyers representing different interests in this car accident. There was an examination before trial, and they were peppering them with questions, and I was interpreting. So one lawyer said to the lady, so what happened? What did you do when the car finally came to a halt? And she said, Nilinua mikono nikashukuru Mungu. I raised up my hands and gave thanks to God. So one of the lawyers said, you were happy that the accident was no more severe than it was. I translated it, rolling my eyes, and she looked at him like he was a moron, and she said, no, I raised up my hands and gave thanks to God. That's what you do. God knows much better than you do, and whatever happens, it is God's will, and you must, as a human being, thank God. This is a very, very devout Muslim lady. and from Zanzibar. So I started to explain this, and that's the first time I was told, wait a minute, you can't say a word because you're introducing evidence. Actually, I wouldn't have been, but that's okay. And they said, you have to be a translating machine. See, we need that Star Trek thing. Then, hey, then everything, there wouldn't be any more problem, right? Okay.
Back on the question that you asked about what can we do to trigger it as early on. And I've just been reading an MA dissertation from Exton by Alice Richardson. And she was trying to figure out how can you get the police to do some early on assessments. And is it possible and practical, and do they have the training? And she went through a number, and this is in the UK, so we're looking at the PACE police sequencing rather than the Reed techniques that's common in the States. But her conclusion, after very careful teasing out all the factors and the testing and the possibilities, she finally had produced a small, what she thought might be a practical, something that the police custodial officers could use. Then she contacted some custodial officers and one other non-custodial to come in and do a focus group with her on it. And the conclusion she came to was that the only practical thing really was to have on the intake form maybe 3 or 4 questions that had to do with language. What was the first language of the person, if you know it, if known? Did you contact an interpreter? If not, why not? And at least and I think there was a 4th question, I forget it right now, but at least it raised the question early on in the intake form, so that, and it might not change immediately, but it might begin to get officers to think about it, and it might be early enough on to begin triggering some support. But it would need a lot of officer training nationwide to have this take place, but that was her pragmatic conclusion at this point. But and I think one other point earlier about an earlier aspect with the attorneys, sometimes the attorneys, when they think that they can handle the interpreting when they're talking with their clients, they also are thinking of their own budget, and they don't want to have to pay for an interpreter to come in and work with them. And that, well, maybe his brother can come in, and help interpret. Well, we all know some of the problems with that, but those are some real practical things. And I think the court is also concerned about the money involved in interpreting, and then they will go for distant interpreting and the language line, and there are limits on what is appropriate with the language line. I think it might be possibly slightly useful at the initial arraignment if it's not a very complex arraignment process. Maybe you have to swear in the long distance person, and it's looked like everybody is swearing in this interpreting box. But beyond that, I think the distant interpreting has a lot of problems with it. There is some distant video interpreting going on now, and there are some companies, I think one out of Florida, that is doing some of this. And I'm not in the position to evaluate the quality of it, but I know that there are attempts, because it is a practical problem with the courts, and they can't afford to, especially for the less commonly spoken languages. What do you do? And there are problems. There's a case that attempted to go to the Supreme Court I think it was from Massachusetts, having to do with the distant interpreting and the liability of the interpreter for the quality of the interpreting that went on. But it wasn't accepted by the Supreme Court to be heard. But there are those practical issues, and I thank you for raising the point that it's got to be early on. I'm going to see what Alice Richardson's going to do next.
Just a very, very quick comment about remote interpreting. Concepts of technology are on the minds of interpreters all the time, because they can feel threatened. But I think the message we have to give to interpreters is, you have to get on that train or you're going to be left behind. I think the future is the future is going to be for interpreters who know how to work with technology in order to enhance their practice. I mean, as an example, in the state of Texas, we have about 430 certified interpreters on the state roster. Texas is a state with literally hundreds of counties, and most of them don't have even one certified interpreter, even in Spanish. And I mean, the reason is because most of Texas is empty, right? So we've got the certified interpreters. If you plot them on a map, you can see them going up and down through the major cities. They go through El Paso and San Antonio, and then they go through Austin and Houston and Dallas and Fort Worth. And then there are a few in random places. So in fact, the Office of Court Administration in Texas actually has two distance remote interpreters on their staff that work full-time in the Spanish-English language pair, because it's a reality in states that have big rural areas. And then I guess the last thing I wanted to say, in addition to more gratitude and thanks for this great conversation, would be that a lot of the comments that all of you have made kind of compound two things that we talk about in interpreting studies a lot. One is the need to educate stakeholders in the process. I'm thinking mostly about attorneys and judges. And then, shoot, I think I forgot the second thing, which was actually more important. The second thing was really about the importance of seeing what happens outside of the courtroom. We've been very, very focused on the courtroom today in our conversations, but many of you have alluded to important things that happen outside the courtroom. I was just thinking of that when the last time we had a reference to the availability of police interpreters and the availability of even going to the scheduler to get your court-appointed drug rehab settled. I mean, or psychological counseling, or appointments in all of the specialty courts that exist, or depositions. There's so many things that happen outside of the courtroom as well, and we're so desperate for getting competent interpreters in the courtroom that we don't really worry about the other things that happen. But those are important areas of research for the future for us and for our students.
Well, I thought to perk things up a little, I'll play devil's advocate for a moment. And we've covered a lot of things that have to do with interpreting, certification of interpreters, competent interpreters, technology. But we haven't touched on what I think is probably the most important thing, is translation non-equivalence. Translation non-equivalence, the fact that English legal terminology does not have really good equivalents in other languages, which makes interpreting also a substandard solution in many cases. And I'll be honest with you, and you may, if you have any, raw eggs and stuff to throw at me, you may do that. But I was recently working on a case where I advised against using an interpreter, which is probably against everything we all believe in, but I thought it was the best course of action. It was a case where the defendant tried to fake lower English proficiency on the basis of 18 hours of recordings. I have established that she actually, she spent 10 years in the US, and she had quite advanced English proficiency that allowed for some very subtle syntactic structures with insertion of F words in very appropriate places. And she also had very extensive legal and financial vocabulary. She was accented, she was no even close to a native speaker, but she had the kind of English many non-educated, lower educated English speakers would have. Her native language was a non-standardized dialect in the Philippines. And having talked to my colleagues from the Philippines, I actually came to a conclusion that having things, English legal terminology translated into that non-standardized dialect will not advance her understanding of the court proceedings. She will be better off listening to the English and getting clarifications from her lawyers in English. So I hope that makes sense too, because I don't think interpreting is always a solution that we advocate. It's even more complicated than that.
This has been a very interesting and lively conversation, and thanks for that. I thought given the low numbers of people we had in the room left, we might not have such a great, interesting, and enlightening conversation, but I thank you for that. Are there any more questions or comments? Then on that note, thank you once again for participating, and we will end the forum right now. Thanks.